Hi, everybody, and welcome to Last Week Tonight Live. This is attorney Arkady Frekhtman, and I'm a New York City personal injury trial attorney, and I'm here live in my office in Brooklyn. I was away for a few days. I'm back. I got a little bit of a tan, and I'm ready to hit the ground running, answer your questions, help people, because our goal here is helping serious injury victims and families. We've done a lot of consults. In fact, I did a few consults while I was away down in Florida, sunny Florida, and I'm happy to do, I did a bunch of consults after I returned. I've done some this week here in New York, so I just take out the time. I've even done some today, I think 2 or 3 today. So I'm happy to do as many as I can. I have to, of course, do my work as well and prepare for trials and other client work, but I want to do as many as possible. So let's see, we have some questions here already. Here's a question from Mauniratu, and he or she says, hello, hi, how are you? Thank you for being here. What is the longest you ever had a case? Mine has been going on for 7 years. Wow, no, I'm sorry to hear that. I mean, a case, it really depends on the type of case that it is. I don't think a case should necessarily always take a long time, right? Some cases can be settled, and if they can be settled, then they get resolved. And if they get resolved, they could be settled quickly. They could be settled in, let's say, as quickly as even 6 months or a year. If they can't be settled, usually the reason a case cannot be settled is because either you're going for a lot of money, right? You want like 5 million, 10 million, and they're not going to pay you that much, right? Then it can't be settled. So you have to go to trial. But even to get to trial, you figure if you can do discovery in a year or two, put it on the trial calendar. Here in New York, most places you wait about another year and you get a trial date. So it shouldn't take more than like 2-3 years. If it's taking a long, long time, there's usually some kind of issue, some kind of problem. Maybe they're getting into a discovery battle where one side is asking for some discovery or some depositions and the other side is not producing discovery, or you're getting into an appeal where you have to go to the appellate court, so you have to wait for an appeal to get decided. Usually there's some kind of problem. That's the only reason a case would take so long. So, but I'm happy to give you a private, personal consultation. It's always free. It's confidential. Just text me 347-566-9595. Okay, let's get to the next question. Miss LPL says, hi, Mr. Arkady. 3-part question. Okay, 3 parts. I like it. I like it. Let's do it. Let's do part 1. Okay, Nassau County slip and fall. Liability is good. Tibia plateau fracture, full arthroscopic surgery to repair a torn medial meniscus. Okay. So yeah, that's a serious case. I mean, and let's see, surgery to repair the tibial plateau fracture with bone cement and PRP. That's a platelet-rich plasma. That's a type of injection. That's very serious. Leg never responded. Now have CRPS. That's the complex regional pain syndrome. I've done that, videos about that. I just had a trial about CRPS. So there's nerve damage. There's a spinal stimulator. There's 2 revision surgeries with 2 revisions because of medical malpractice. And there's $50 million in insurance. What would be your demand or settlement opportunity with CRPS confirmed by 6 doctors and 3D bone scans? And can you do a video about CRPS? Yes, absolutely. I can. I will. Yeah, I've done a few already. I did a video about that trial that I did for CRPS, but my case was a really mild case of CRPS in a young lady. She was like 19, and we got $535,000. But a case like this, I mean, look, that's a major, major, major case. I don't, I'd have to really look at the file to tell you. If you want to text me, 347-566-9595. What I've been doing for other people is I could look at the file in, e-law or NYSIF. That's the New York State Civil Electronic Filing System. So that's the public file, right? Anybody could look at it. You could just log in as a guest and you could look at all the documents like the summons and complaint, the bill of particulars is going to have all your medical records. I could review everything for you, and then I could tell you what I found and what the value can be. So I'm happy to do that for you, yeah. But I mean, look, I really think a case like that, if it's true CRPS and you have it diagnosed, a case like that could be worth more than 10 million easily. I mean, if I was trying to settle it, I could send them I would speak with you to see what you would be happy with. But let's say you would be happy with 10 million. So I would send them a letter and I would say, okay, pay us 10 million. You have 30 days, right? So by let's say May 4th, right? May 4th at 5 p.m., you have to pay me 10 million. If I don't get it, that's fine. I'm going to go to court and I'm going to go to a jury and then we're going to let the jury decide. But just know it's not going to be 10 million anymore. If we're in front of a jury and we're giving them all these injuries, right? Including the economic damages, the future lost wages, the future medical expenses, and non-economic damages, which are most of the case, right? The economic damages are the smaller part of the case. The non-economic damages are your pain and suffering. It's also your loss of enjoyment of life. That's a bigger part of the case. That could be, 30 million right there, and then the other part maybe is like 10. So I would be probably going for the full 50 if I was trying a case like that. But that's a major case. Yeah, just text me. I'm happy to chat with you, answer your questions. Like I said, it's always free, confidential. The other thing I could do is if you have somebody, sometimes people have an attorney or they don't have an attorney, right? If they don't have an attorney, they might want to know about an attorney, or if they have an attorney, they might not be sure if their attorney is communicating with them, responding to them, or just if their attorney is a real trial attorney. So what I could do is I could search in one of these databases that I have, like Westlaw, Lexis, a jury verdict reporter. I could search the attorney and I could tell you that attorney's prior settlements and verdicts, just so you would know about, what this attorney is capable of. Just I really feel like, the public should be educated. There shouldn't be like these private databases somewhere, right, with access to lawyers. But then the public, the actual clients, the actual injury victims, just there's a wall, right? And they can't find out what these attorneys. So they think, oh, I have a trial attorney. They're going to go and get me 10 million. And in reality, if you do a search on that attorney, sometimes, the only verdicts they have are like for 20,000 or 0, 0, 0. They just have a bunch of goose eggs. How is that fair to you guys? How is that fair to the public? See, I'm more like, I'm trying to help people. So yeah, just text me about that. Okay, let's go to the next question. Darren Proctor, is it all right to go to a defendant deposition? If so, will they question me also? No, they won't question you. You can go. Yeah, if you're a party, you could just go and sit in on it. Absolutely. Yeah, Mr. Proctor, somebody I've spoken with, he's texted me before. I'm actually helping him. I'm waiting on an attorney to get back to me about Mr. Proctor. And if they don't, then I have other people lined up. I just wanted to wait for this one response, but for some reason it's taking a while. So if it takes too long, we'll just move on. So I'm on top of it. Okay, and then Preacher says, do you bring in an economist to give their opinion before you do a settlement demand letter, or wait until a lawsuit is filed? Yeah, I usually do my settlement, letters after a lawsuit has been filed, just because, before a lawsuit is even filed, you can't really get much money on a case because it's in a claim, right? Somebody's claiming that they're entitled to money and it's pre-litigation. And so they put a claims adjuster on it. And the claims adjuster only has authority for maybe up to 25,000 or some limit. So I don't even talk to them. Why waste your time? They're not going to be able to do much for you. I file a lawsuit. Now I have a litigation adjuster. They still have some kind of limit, maybe it's more, maybe like 250. And then there's another adjuster up to like $1 million. And then there's the adjuster who does over 3 million. It goes by layers. That's how they're structured. That's how they set up their corporate structure. So it's just the way they work. So yeah, but yeah, I would get an economist. If you need an economist, if you have lost wages, yeah, of course, get an economist. You could do it. You don't have to do it that early. You can calculate lost wages yourself, right? If you make 100,000 a year and you can never go back to work, and let's say you're going to work to age 65 and you're 40, so you just calculate 25 years times 100,000 a year. So whatever it comes out to, right? That's like 2.5 million, right? 100,000 a year times 25 years. Now, of course, there's going to be like inflation, and there's going to be other things like household services. So, the 2.5 million is very rough. It probably won't be 2.5. It'll probably be like 3.7 or whatever. But, you get an idea yourself. But of course, yeah, I would just hire an economist, Okay, so, but that's a good question. And then Dominic is here. Hi, Dominic. Yeah, I have to call him back. I apologize. I've been so busy. I haven't had a chance to call everybody back. He says, hi, Arkady, it's Dominic. What happens if the insurance company responds with a preliminary conference proposed? I'm not sure what that means. The insurance company doesn't respond with anything because, they don't really get involved. The insurance company just pays the money and they have an adjuster, right? The adjuster decides how much money to pay. Now, the insurance company hires a defense lawyer. So everything is done through the defense lawyer. The defense lawyer is the one who talks to us, that handles everything. Some adjusters even say, hey, you know what? Don't call me. I don't want to speak to you. Just deal with the lawyer. So a preliminary conference is when you go to court and you actually show up to the conference. You have a judge there, and then you fill out an order, and it's like a scheduling order. It's like, when are you going to have the deposition of the plaintiff? When are you going to have the deposition of the defendant? When is the plaintiff going to give authorizations or copies of medical records? When is the defendant going to give, whatever they're supposed to give, like property damage photos or, whatever they have, whatever you want to get from them, depending on the type of case it is. If it's a car crash case, you probably want like video of the car, photos of the cars, repair bills, whatever you want to get. So that's all it is. The insurance company doesn't get involved with preliminary conferences. Okay. And then I see here, your mother is here. Wow, my mother's. I hope it's not my mother. New fan. My question is, my case has been going on for 5 years. I have, he mentions a lawyer. Okay. Are they a good firm or billboard lawyers? I mean, I don't want to talk about, specific firms, like this in a public forum, but I'm happy to answer your question. If you want to text me, 347-566-9595. I can give you, my opinion, and I could even do, like I said, I could do the research, right? I could look them up in the databases. I could show you the verdicts, and then you could see for yourself, right? You could see the settlements and the verdicts that particular law firms or particular lawyers have achieved. And I've done it. Like today, I checked. Today was funny. Today, 2 people from Pennsylvania contacted me. One in, I think, Philadelphia County, and the other one was like another county, maybe Lancaster, somewhere nearby. So I checked both, and it was interesting. They both had both counties. I just checked the counties to see who's getting the top verdicts, and both of them had really high numbers for some of the motor vehicle and other serious personal injuries. So I could do it for specific lawyers. I could do it for injuries. So I'll probably do more videos about that too, more recorded videos. I just have to find the time to do this research and to shoot the video. Okay. And then Truth Seeker says, good evening, Arkady. I was wondering if you were able to get any cases about bradycardia, just so I can get an estimate of what my injury to my heart could possibly be. Thank you. It's good to see you. Yeah, let me do that. Bradycardia. Yeah. Yeah, I think I remember this case. Right. But the only caveat is that, any kind of, cases I could research are going to be personal injury cases. And I think your case, I don't know if I'm remembering this correctly, but your case may be a workers' comp case. So that might be different, because personal injury cases are usually worth way more. Workers' comp cases are usually less. But I mean, the injury is serious, obviously. Bradycardia, that's the heart. So I'll check that out. I'll do that. Okay, and then iGod Mode says, I'd be interested in knowing, but would feel better if I paid you something for your time. No, I mean, you don't have to pay me. I mean, if you'd like, you could give us like a super thanks here, for the channel. But so we could do more content, so we could do. But we just want to help people. We're okay. You could just text me. 347-566-9595. I'll probably set up like some kind of. I know they have this app. It's called Calendly, like a calendar. And then I'll choose some like office hours, and then maybe I'll block out like half-hour time increments or 20-minute time increments, so people could just choose the time themselves, and then we'll just have the call scheduled by Zoom or by phone, however you like, that way. Because I'm trying to make all the appointments myself, and I'll go a little crazy. It's a little too much because it's good. I'm getting some response from you guys. People are interested. People are interacting, which is good. But I just don't want to it's hard for me to keep all these schedules because I also have court and I have depositions and I have research and I have other things that I have to do. So, but I think that would be good. That way, it would like automatically scheduled with their app. It puts it right in the calendar, and then you could and then it'll be good for you too because you'll know when it's on, and it'll be easier. Okay. And by the way, if you text me, the best way to do it is just to text me your name. If you don't want to give me like your full name, for privacy, that's fine. You could just say I'm John. And then text me the facts. Like, for example, I was stopped at a red light, I got rear-ended, or I slipped and fell, there was a puddle, or, whatever happened. I was in my living room and the ceiling fell on my head, whatever, just so I could have a picture of what happened. Just like that, just like one sentence, and then tell me your injury. Like I had a torn knee with surgery, arthroscopic, or I had a fusion at a C3, C4, as much as But the whole text could just be like 2 sentences. You don't have to text me like a lot, because sometimes people text me a lot, but I can't always read a lot. So I get busy. I have court. I have other things. Like this one lady was texting me today. I was talking about China hypnosis. I don't know, like this long thing. I don't know about hypnosis in China. I just know about what I do, personal injury. So I just keep it simple. Okay, let me see. Leonardo is here. He says hello. Hi, how are you? Great to see you. Leonardo is one of our all-time regulars. He's a nice guy. He's always has good questions. A really smart guy. And then Truth Seeker says, would you have attorneys settlement access in Nevada to look up my attorney to see what my settlements are in the past? Yeah, I could. Yeah, Nevada, absolutely. I can look it up anywhere, the whole country. Yeah, absolutely. Of course, Nevada is a big place. And I know a lot of really good trial attorneys in Nevada too. If you need any help, just let me know. Okay, and then Leonardo says, how long does it take a defendant to send a release after the settlement in a personal injury case usually? I mean, to send a release really doesn't take long, maybe just a few days. I don't know, because like you don't have to wait for the defendant to send a release, right? If a case is settled, like a personal injury case is settled, you could just use your own release. Just use a general Blumberg form or use your own release. Now, if the defendant says, I don't like your release and I want to use my own release, then they have to give you their release. They can't say, I'm going to settle the case. I'm going to settle it for $1 million. And now I'm going to wait 5 months to give you a release. That doesn't make sense, right? You could then make a motion to enforce the settlement and enter judgment and get interest. They can't do that. So no, just a few days. Okay. And then your mother says trip and fall, back surgery, knee surgery, and 10-shot back and neck. After surgery, they admitted liability. Okay, so if they admitted liability, that's very good, because with trip and fall cases, that's the major fight, right? Because whenever someone falls, invariably the defendant is going to say, well, you shouldn't have fallen, or you should have been more careful. You should have looked where you were going and things like that. So, the fact that, if they admitted liability, that's really good right there. And you have a serious injury, obviously, right? You have a very serious injury. All these different surgeries and everything, that's very, very serious. Back, so I don't know, what kind of back surgery, if it's a fusion, knee surgery, if it's a arthroscopic. And then I don't know what 10 shots. I'm not sure what 10 shots are, but some kind of shots, maybe epidural steroid injections. It's very serious. Yeah, just text me about that. 347-566-9595. Okay. 1 second. I'm just going to clear something here. My computer says I have to clear some space. Maybe I have too many tabs open. The computer can't keep up. Okay, let's see. And okay, I think that's better now. Free up space, it says. Okay, let's see. And here's a question from Kevin. Thank you for all your advice, Arkady. I am now in the deposition phase for my injury motor accident. You've taught me so much. Oh, thank you. Thank you for watching. Yeah, I mean, I'm really glad that it was helpful. I just want to help, and as much as I can. And then iGod Mode says, I'd really like to have you look up my lawyer and case, but I'd want to pay you. Oh, yeah, well, yeah, just text me. You don't have to pay me. It's fine. I'll look it up. It doesn't take too long. It just takes a few minutes. I could email you the results or text you the results as well, and we could chat. I'm happy to just help out and chat. And then Nassau Boy, attorney, you are the GOAT. Oh, nice. That's good. I feel really good about my new attorney. Oh, that's awesome. Thank you so much. Yeah. That's really nice. Thank you for saying that. I appreciate it. And then Jeff Burke says, how long does it take usually to set up a mediation meeting? I mean, to set up a mediation, in New York, I would say usually about a month, just because all the mediators are usually backed up, right? Especially if it's a popular mediator that everybody wants, they're going to be a little bit backed up. So let's say you want to get a mediation, but you want to use a popular mediator, so they might not be available till May or June. So it's setting it up itself is easy, right? You just, as long as the defendant agrees and the plaintiff agrees and you agree on the mediator, the judge, then it's just a question of the mediator's availability and the counsel's availability. Like sometimes counsel is in another trial or in a deposition, or they get busy calendars. So just a matter of picking an open spot. Usually you want a few hours. And the important thing, I've said it before, but the important thing is don't agree to a mediation without a good faith offer. What that means is, for example, if I think a case is worth $1 million, sure, I'll go to mediation, but I have conditions, right? Prerequisites. One of the conditions is give me a good faith offer. And what I mean by that is if I have 300K on the table, okay, fine, I'll go to a mediation because you're giving me a good faith offer. There's 300,000 on the table. I'm trying to get $1 million. So look, okay, maybe I won't get $1 million, but if there's 300 already at the mediation, we can talk. The judge will, push the insurance company to come up, and maybe the case could settle for 600, 700, 800, reasonable. Now, if they're refusing to give me any offer and they're just saying, let's go to a mediation, it's likely to settle, I don't know what that means, right? We could be in different ballparks. You may be thinking, yeah, it's likely to settle. And then at a mediation, they'll offer me like 15,000, but I'm looking for $1 million. So what's the point, right? I have to waste my day. My client has to waste his or her day. My client is there. My client gets their hopes up, right? Thinking, oh, I'm going to get the case settled. And then what they do, and they love to do this, they love to then dash your hopes, get your hopes up, and then be like, no, this is a bad case. This is only worth 15,000. So that destroys a client's hope and makes the client think that their case isn't worth anything. When the case really is worth something, it just has to be obtained through a jury, you understand, not at a mediation. A mediation is just, a voluntary payment. It's like a settlement. There's no reason to even have to go to a mediation. If they want to settle the case, right, pick up the phone and just give me the $1 million. I'll take it, and that's it. We'll hang up. Why do we have to go to a mediation, pay a mediator $600 an hour for what? Like, for what? You know what I mean? Like, it's just the pony. What do you call it? A pony show. Like, I don't know. But the whole point is that don't agree to the mediation unless they're going to give you a good faith offer, because they want to disillusion you and they want you to think that, you can't get a lot of money, because then they win, right? Because then they get to keep their $1 million in their pocket and they give you a little bit. They're like, oh, here's 50,000, here's 75,000. That's their whole game. And they want to keep most of the money. Plus, the other thing it does is it breeds discontent between the client and their lawyer, because the client is going to say, well, why did you bring me here? Didn't you ask? Didn't you get a good faith offer? Why'd you bring me here? Bring me here for what? So I could get like lambasted and told how bad my case is and that, my case isn't worth anything, and get like 15,000. This is an insult. And then the client gets mad at their lawyer, and they like that too. I guess it's all like a game that they play. So just be careful. That's all I'm saying. Don't get your hopes up for mediations. I mean, I go to mediations. I settle cases in mediations, but you have to set ground rules. And all the best trial attorneys, they'll tell you the same thing. They set ground rules. And if they don't follow your ground rules, don't even show up. Just do a letter, a settlement opportunity letter, and say, look, pay me the $1 million. You have 30 days. Once that deadline expires, it's going to be 3 million or whatever, and that way, that's it, right? Everything's bright line. Everything's, in bold, in text, in an email, or in a letter. You can't mistake anything, right? Everything's right there. And it's a beautiful thing. Okay. And then Darren says, can you make changes in your deposition? And if so, will it hurt your case? No, you can make changes. I mean, the only thing is that you have to say, the reason for the change. So for example, like if you want to make an addition to an answer, that's fine. But if you want to completely change something, right? For example, if I say, okay, I fell because of a water puddle in my deposition. And then I want to say, you know what? No, I fell because of a banana peel, and that's my change. That's going to look really weird, right? Because the way they do it is, first of all, they're going to say, well, what's the reason for your change? You could say, I misunderstood the question, or I wanted to add something. And like I said, adding something is fine, but you can't make like a material change like that, because then they're like, wait a minute. And then what happens is they read both, right? So they'll read, I fell because of a water puddle. Okay, so you fell because of a puddle. Then they're going to read, no, but now I'm changing it. I fell because of a banana peel. So that makes it like, that's like, wait a minute, boom. It's like, you don't know why you fell, right? And then it's going to be bad. So you can't do that. But small changes, yeah, sure. It's called an errata sheet. And you just, you make some changes. It's not a big deal. Okay, and then your mother again says, lawyers said the case is stayed because the death of the owner. They said we will be going to court on the 28th of this month to get the stay lifted. What is the process for that? Oh, yeah. When the owner dies, you have to get an estate appointed. It's like a surrogate's court issue. which is a trusts and estates type law. So there's a surrogates court, and that's what they do, right? In New York. I don't know if you're in New York or in another state, but yeah, in other states, they might call it like probate or intestacy, but you basically need somebody to step into the shoes of the decedent, right? Because if it's an individual owner and they're dead, there's a stay, meaning there's a moratorium. There's no case because the person is dead. You can't sue a dead person. So then someone else has to be the administrator of the estate. Usually it's a relative, or, if it's a company, they might have a company step in, however they do it. And then, so the process is fairly straightforward. Your lawyer should be able to do it, or if they can't, what they could do is they can counsel and partner with one of these trusts and estates lawyers, and then those lawyers can help them. We've done that in many cases. In fact, we have a case now with the same thing, and it's just taking a long time because of the court's a little bit of a bureaucracy, but really it should be a simple thing. You just put someone else in there and just move the case. But I don't know. The court system doesn't want to make anything simple. Okay, and then Dominic says, when do you issue a jury order? A jury order. I think you mean the note of issue, or when you file the note of issue, it has something. Note of issue means all discovery is done and you're putting the case on the trial calendar. And when you file a note of issue, you can check jury. So that means that you want a jury. So yeah, of course, you always want a jury. You don't want to do a judge. I mean, some lawyers like these trials just with judges, but I think it's a big mistake because judge is going to give you much less usually than a jury. Okay, and then Bagged Boys says, where can I learn to prepare for my deposition? Oh yeah, so I mean, really, your lawyer should be meeting with you. We talked about this today, actually, on the consults I did in the morning. So somebody was telling me they have a deposition and the lawyer never even talked to them at all and said, I'm going to call you like the day before for like 10 minutes or something. It's crazy. What you really want to do is have your lawyer talk to you at least 3 or 4 times and prepare you thoroughly for a deposition, because a deposition is very, very important, right? There's a transcript of what you say. Sometimes it gets recorded and they have an actual video. And always in a deposition, your the other side is going to like read the deposition, and then the lawyer for the defendant, the insurance company's lawyer, is going to write a report about how you did, how you appeared, how you looked, what you wore, whether a jury would like you, things like that, and how you answered the questions, whether you answered the questions being asked or whether you were evasive, things like that. So you want to do a good job. So the first meeting, I always think, the first meeting should be to answer the client's concerns, right? Because people who get injured, they don't know about depositions. They're not lawyers. They don't go to hearings to get asked questions, right? They're just used to, common everyday conversations. So then you have to, calm all their fears and ask them, hey, what are you worried about? Do you have any questions? Answer their questions. That's the first meeting. Now, the second meeting, once, you put you made them calm, you put them at ease. The second meeting, you could talk to them about things like, you could say, okay, let's go over how the accident happened, how you fell, how the car crash happened, whatever it was, right? And go through it in detail. And then also talk about their injuries, how it affected their life, do a deep dive. So you could talk about some stories about how their life changed, see if they have any other witnesses like friends, neighbors, like circle of friends, community witnesses, to help paint a picture of how their life was changed, especially if it's a serious life-changing injury, right? And so things like that, yeah, I think you need at least 2 or 3 preps. I did a video. I don't have the link right now, but if you look in the channel under videos, it's, if you sort it by most recent, I think it's called Super Depositions. It actually has me like one of those AI Superman, and it's called Super Depositions. So if you read that one, if you watch that one, it really goes into depth. It's like 30 minutes. It goes through all the questions, all the ways that they try to trick you, not all the ways, but many of the ways they try to trick you, and what to do and things like that. So take a look at that one. I think it will be helpful. But yeah, your lawyer should really be preparing you for a deposition. That's very, very important, because if the deposition goes badly, then the whole case could be lost. That's a very, very important thing. Okay. And then Christian Moore says, when a plaintiff has completed an IME, what usually occurs next? Okay, yeah. So if you've already completed the IME, then the next thing after that is usually, it depends on whether or not your lawyer has done a deposition of the defendant. If they have, then if that's the final piece of the puzzle, the IME, then you just certify it as trial ready and you go on the trial calendar and you just wait for the trial. And of course, there's other things you have to do. Like, for example, you do have to do subpoenas. There are certain notices that you have to do, like MRI exchanges. So you could use MRI films, use them in evidence. I think they're called 4532 exchanges here in New York. There's also like CPLR 2303 exchanges. We have like a whole trial prep, paralegals and a team that does that. But of course, the attorney has to supervise it, and then it's called trial preparation, and then you have the actual trial. But that's it sounds like you're towards the final stages, because that's usually when you're far along. You have the IME, so that's good. Okay, and then Oseni says, hello, please do scapholunate ligament tear settlements in New York. Okay, yeah, I'll take a look at that. I don't know if there's going to be much on that scapholunate ligament, but I'm happy to do that. I'll take a look, and I'll do that for you. I think I answered this actually in a recent. I don't think the video came out yet, but I recorded a video when I was down in Florida about scapholunate ligament, about this question, and I just said, look, you have to understand that ultimately value is not determined by a type of tear, right? Like scapholunate, like that's a good example, right? Scapholunate ligament. That doesn't mean because someone else obtained a certain amount for a scapholunate ligament tear. Let's say someone else, right, 2 years ago obtained, I don't know, a good amount, like 500,000 for a scapholunate ligament. It doesn't mean you're going to get the same amount, right? Because it just depends on how that case was prepared and how that case was presented, right? And the same way, if someone else had a scapholunate ligament tear and got a bad amount, like 10,000, and it's so little, and you want much more, it doesn't mean you're going to get 10,000 either. The past is just, it is like for some things you could use it in some ways, but I guess what I'm saying is that diagnoses like that don't determine value. What really determines value is the way that you prepare the case overall. It's very holistic. It's like you have to look at the whole enchilada and the way that it's affected your life and the way that you could explain that, right? So if you have a scapholunate ligament tear and it healed and you're okay, it might not be worth much. But if you have a scapholunate ligament tear and you have a small child and you can't pick up the child because of it, or you can't work because of it, and your whole life has changed because of it, well, now maybe it's worth millions and millions of dollars, right? So it's the overall picture. But I'm happy to do the video. Yeah, I'll take a look at it. Okay, and then CC says, my case is over 6 years in the making, and I won summary judgment in less than 2 months from the submission, and my lawyer said he hasn't seen anyone win so quickly before. Oh, that's good. Well, yeah, but if why is it going on for 6 years then? Why didn't he just it's good, but why didn't he just file the lawsuit and then just, get you summary judgment 6 years ago? Then you would have gotten interest for 6 years. It would have been better. But that's still good. It's always good to get summary judgment. Okay, let's see what other questions we have. Your mother says fusion. Oh, that's the injury. Yeah, fusion is really serious. That's usually multi-million. And then Dominic responded. And then the hire says, if you do a great job at a deposition, is there a possibility to scare the defense? Yeah, I think nothing really scares the defense except for these letters, right? We just say, hey, pay me like $1 million within the 30 days. If you don't, then we're going to go for like 5 million. They really don't like that, right? Because it kind of blows up their world. Because the way that they set everything up is they want you to be like a beggar, right? They're imagining they're rich, right? They're, I don't know, like Elon Musk or Warren Buffett or whoever's the richest person, George Soros, right? Like Mr. Moneybags, and they're sitting there with a bag of money. And then you come and you're like, I want a piece of that money. And they're like, okay, well, how about I give you 1 coin, but I still keep the bag, right? So if you do it the old school way, you come to them and you say, I want $1 million. What they're going to say is, $1 million? Are you crazy? This case isn't worth $1 million. How about 20,000? And they want you to come down and say, okay, well, I'll demand 300. And then they'll say, okay, how about 80,000? I'll demand, 150. And then they'll say, okay, well, if you demanded like 150, maybe we could settle the case for, 95. I don't have 100. I don't have 6 figures. They love saying that. They love saying that, by the way. I don't have 6 figures. This isn't a 6-figure case. 6 figures meaning 100,000. So then, but if you really push them, they might say, okay, fine, I'll settle for 100,000. You know what I'm saying? But what did they just do? They just saved 900,000, right? So that's the way they like to do it. That's their old school way, and that's the way 99% of lawyers negotiate, right? So what they do is they just drag them down. But the way I like to do it is this other method where you evaluate the case and you have a focus group, and it's based on research and it's based on what the client wants and what's fair. It's not crazy, right? I'm not going to say, oh, I broke my finger, I'm going to ask for millions of dollars. But if it's a life-changing injury, if it's a really big injury, you can do this, and you say, look, okay, pay me $1 million within 30 days. If you don't, then I'm going to go to court, but it's going to be like 3 million. And then you keep stair stepping on up. So by the time you're about to pick a jury or open your opening statement, you could be at 5 million. So you're doing exactly the opposite of what they're doing. They're going down, you're going up. So you see what I'm saying? So that really scares them. Deposition, I mean, sure, if you do a good job, I mean, if you answer the questions, if you are honest, if you tell like a story about how it affected your life and how your life changed, especially if they think that it's compelling. Like, for example, if you do something for other people, whether it's your family or even strangers, sometimes people do good deeds. Like I have this one client, he goes to like a center and he gives these talks to prevent others from becoming, let's say, alcoholics or get them into like rehab. It helps people. And now he can't do that, right? Because he's injured. So things like that could scare them to an extent. They might say, wow, jury is going to allow for a lot of money for someone like that. So yeah, I think it's possible, but I really think nothing really scares them more than this, the system that I am using. So it's a good thing. Okay, Darren says, can you tell me how much my case is worth? Yeah, I mean, again, I don't want to, I don't want to talk about specific cases in a public forum because we're live right now, But yeah, just text me. Just text me. We could do another call. Just 347-566-9595. Yeah, I'm happy to chat with you again. And then Young's Even Gaming. Hi, I have a two-part question. If you're in a suit against an insurance company of a government-covered vehicle, why does the notice of deposition have 3 defendants on it? The insurance company, city, and driver. Why does it have 3 defendants? I'm not really sure. It depends on where it is and what's happening. But if you're suing an insurance company, I mean, usually you don't sue an insurance company. Usually you sue the defendant, but the insurance company defends, meaning like, okay, let's say I get into a car crash, right, with ABC Company. So ABC Company has, let's say, Geico or Allstate. So Geico or Allstate is ultimately going to pay, right, based on the policy, whether it's 100,000 policy or 1 million policy. But I don't sue Geico or Allstate. I sue ABC Company. But then if I win against ABC Company, Geico or Allstate will pay the amount, you see, because that's the policy holder. The policy holder is the defendant, and then the insurance company is the one who, just basically pays the policy if you win the verdict or if you agree on a settlement. That's usually how it works. But if you're asking like why someone's on a deposition, it's hard for me to say without looking at it, without knowing all the information. Okay. And then Christian says, very interesting. Thank you. Yeah, thank you so much. Thank you for being here. Miss LPL says, what was was your biggest verdict in the last 5 years? And what is your lifetime trial record? Yeah, no, I mean, we've had I think one of the biggest ones, we had a few big ones in the last 5 years. Last 5 years, because of COVID, we haven't had that many trials. But in terms of settlements and verdicts, well, we had that one recently in August. That was 3.5 million. We had a settlement for, was it 2.8 million in a construction case. We had a lady who fell. That was about 2 million. We had a truck accident, 2.4, 2.5 million. I mean, the biggest probably was another trial attorney that worked with me. This was a little while ago, but he got a verdict like 69 million. And some of the other lawyers that I partner with all over the country, they're excellent trial lawyers. Just last week, one of them, I was out in California doing a workshop, and that week that I went out to California, one of the lawyers that leads the workshop, he actually got a $61 million verdict in Indianapolis, I believe it was. I did a video about that one. It's the one with Tesla and the motorcycle. So yeah, I mean, you can get some really big verdicts. The problem with too much of a verdict is how do you actually get the money, right? Sometimes you can get a 60 whatever $million verdict, but there's only 5 million in insurance, so then it's hard to get more. But then it opens up other questions, right? Sometimes you could open up policies and you can go for more money through bad faith. Now, a lot of states have that. New York has it, but it's not so great in New York. It's tough to do in New York. Okay. And then Young's even again says, does the insurance company cover everybody, even if the driver was off duty but still using a car for personal reasons and is at fault? Yeah, I mean, as long as there's a policy on the car, and if the driver has permissive, it's called permissive use, as long as they have permission, right, to use the car. Whether they're on duty or off duty is more like whether they were working. But the car should still have insurance, even if they're not working, right? If I'm going to buy ice cream, the car should still have insurance. But now, if there's no permissive use, that means someone stole a car, then it gets tricky, right? Then there might not be insurance because it's a stolen vehicle. So as long as you have permissive use, you should be okay. And Leonardo says, what happens first, the mediation or the pretrial conference? Well, I mean, you don't have to do a mediation, right? Unless it's court ordered. They used to have court ordered mediation, like in Manhattan and some places. I don't even think they have it anymore. I haven't really seen too much court ordered mediation anymore. So mediation is something you can do if you want, right? But you don't have to. Whereas a pretrial conference, you're always going to have. So usually the pretrial conference, I guess, would happen first. And then Almighty says, what happens if you have a disability and PTSD, that's post-traumatic stress disorder, and can't do a deposition for the trucking insurance? Also, what if the lawyer sent a demand for the policy limit, 750K? How can you recover more? Okay, yeah. So if you can't do a deposition because you have severe like traumatic brain injury or PTSD, what I would recommend is maybe having someone else step in as guardian ad litem and have that person do the deposition. And then you should, you could make a motion to say that you're not able to answer questions because of your medical condition. And then you would get excused from doing the deposition. It depends on the judge. Sometimes they might still try to take your deposition, so you just do the best you can and have the lawyer spend extra time preparing you and teaching you how to be calm and relax so you don't get like flustered or angry. So yeah, and then what if the lawyer? Well, if the lawyer already demands, that's my whole point, right? What I was talking about earlier about the two ways to do it, whether you start high and then they laugh at you and make you come down, versus being reasonable and say pay this by 30 days. The whole point is that once the lawyer makes a demand, See, I don't like the word demand at all, right? Because I'm not demanding anything. I'm just telling you what civil justice is. Like, for example, civil justice in this case is $1 million. I'm not saying I'm demanding $1 million, right? Why am I demanding anything? It's just the equal trade dollar value of what they took. They took away someone's health, like they took away your health by giving you PTSD or giving you a TBI. They took away someone else's health and life by having him have a fusion at C4, C5, C6. They don't want to have two levels of their spine fused. They want to be able to have their spine be a hinge joint and bend the way a normal human spine should bend, right? So what is that worth? The equal trade dollar value of that is many millions of dollars. It's not cheap, right? Life isn't cheap. So that's kind of like my point. But if a lawyer already goes in and demands 750, it's hard to get any more, because once you start off at 750, they're going to say, okay, how about we give them 100? Let's see how far down we could drag them. You see? So like you can't go you demand 750 and then tomorrow come back and say I want 770. Well, they're going to be like, what are you talking about? You already said 750. That's it. We have it written down. You never can go back up. That's why I don't like to even play that game. I just say, look, pay me whatever I think, I evaluate the case, whatever the case is really worth. Like pay me 1 million or 3 million or 10 million, whatever the case is worth. You have 30 days. If you don't, that's fine. But then if I go to trial, it's going to be much more. It's just a better way to do it as opposed to playing their games. It's their game. Why would I want to play their game? And then it makes me look weak, right? I'd rather be strong and I believe in my case. Now, the only issue with my whole system is you have to be a trial lawyer to do it, right? And you have to be willing to stick to your guns and go to trial and get verdicts, right? And sometimes you might say, hey, I want 10 million, and then somebody might go to trial and do the case and lose, right? That's a possibility, but that's just part of it, right? That's part of it. That happens. All the best even though I think the lawyer who got the 60 million, it was like 61 million. The case before that he did, it was like a tough case with somebody like spilled coffee, and that was a loss, and he lost that case, right? So it happens to the best lawyers. The best lawyers, sometimes they win, sometimes they lose. But my point is, you have to be fearless and you have to be willing to go for it, because some people aren't even willing to do it and they're just bluffing. But if you're just bluffing, the insurance companies sooner or later they're going to call your bluff, and then you're going to be in trouble. So yeah, okay. Oh, and Nassau Boy is here. He says, I want to thank you for getting me the best trial by human lawyer in Atlanta. Oh, yeah, yeah, absolutely. Okay. Oh, great to see you. Yeah, thank you so much. Yeah, absolutely. Yeah, no, I know some excellent lawyers, yeah, in Atlanta, all over the country. I try to do that research. Like today, like I was saying, I was doing research in Pennsylvania to see which lawyers are getting the top verdicts. Like some of them were crazy. One of the verdicts was like actually for like 900 something million. It wasn't, it was a different kind of case, but you could see it by the amount, and then you could see who's getting the top verdicts. Yes, I just want to be able to help. Okay, and then that guy says when a state has a PPD scale that says what every PPD rating is worth, is that what it is no matter what? Washington State. Uh-huh, a state rating. I'm not familiar with that. What is I'm not familiar with PPD. I'm not sure what that is. So maybe, yeah, maybe like type a comment. Let me know what PPD is because maybe I'm not familiar. Maybe is that a workers' comp thing, or I'm not sure. Washington State, a rating. I know workers' comp has ratings. I don't do workers' comp, just so you know. I do personal injury, meaning like, car crashes, motorcycle crashes, truck accidents, trip and falls, ceiling collapses, construction accidents, like falls from ladders, scaffolds, all those kinds of cases. So workers' comp, I know, pays for your lost wages. It also pays for your medical bills, right? So it pays other people, like doctors, to treat you. But oh yeah, partial permanent disability. I think that might be. So it's a rating, right? So who's giving you the rating? Is it the Workers' Compensation Board? I'm not sure who's giving the rating. You know what I mean? You wouldn't have that with the jury trial because with the jury trial, a doctor could testify that you have let's say, a disability, but it doesn't. It's just the testimony. So they could choose to believe the doctor who says you have a disability, or they could choose to believe the other doctor, right? Like the IME doctor might say you don't have a disability because he's the insurance company's doctor, and it's up to the jury to decide. So that's what I do, the jury trials. So I think you're talking about um, some kind of state rating. So yeah, I'm not too familiar with that. Okay, and then your mother says, I have not been working. How does that affect my case? Would it be lower or higher? Well, no, it would be higher because look, if you're not working, if you were working before, you have lost wages, right? Lost salary. Let's say you were working and you're making whatever, 50,000 a year. Now you're not working, so you're losing that 50,000 every year. So every year you don't work, the way it works is, let's say you had your accident 5 years ago. So you're entitled to 5 times 50, 250 for the past, right? Let's say 2019 up until 2024. And then you're also entitled to, if the doctors say you can't work in the future, you're also entitled to future lost wages, which are today, depending on your age, up until you turn 65 or whenever you're going to stop working. Some people want to work longer until 70, right? So you can get all those lost wages. So it's a good thing. It helps you. And then also, I think there was a second question. P.S. I don't have any work history. I was working before the accident, but not long. Oh, I see. I see. So you were working before the accident, but not long. I think that's okay, though. It doesn't really matter. As long as you were working and you could show like either pay stubs or you could show income taxes, or in some cases, I've seen case law where people are even working as, illegal aliens because they're here, their immigration status is illegal, but they're working and they're making money and they can even claim lost wages. I've seen some case law on that in New York. So it just depends. You have to do a little research, but you should be okay. And in fact, there's something called unrealized occupation. So if you're studying to be someone, right, but you're not even working, you're just studying to be someone, but then you can't become that profession because you get into, let's say, a car crash, you can recover for something known as unrealized occupation. And it's not that hard to prove. Like I had a case where a guy was working as a waiter, and as he was going home after, 2 a.m., after he was a waiter at a restaurant, he gets hit in the pedestrian crosswalk by a car, breaks his clavicle bone, so he can't go back to school because he was also studying to be an accountant. So then, he still went back to and became an accountant, but he lost like 3 years because he couldn't write. He had a really bad fracture. So he lost 3 years. So we sued for those 3 years, and we had an economist say, well, an entry-level accountant makes whatever 60,000 a year. And we got that 60 times 3, 180. I think the jury gave us it was like 150 or 180 in unrealized occupation. We got that money for him. So it's fairly straightforward. Okay, and then the higher says, what's the largest settlement that you recovered from a truck accident that required surgery, but the client was adamantly against surgery. The trucker is at fault and they are not denying liability. I mean, the largest one that we've got, I don't know, it's hard to say, but like I think I've gotten some. Oh, you mean you're saying without surgery at all? Like so the insurance company says, I mean the doctor says that the client needs surgery, but the client doesn't want to do it. I know I had one case with a truck accident. This was a guy who had a truck accident, I think on the George Washington Bridge here in New York, but he lived somewhere else, like in Virginia. Really nice guy. This was many years ago. This was like over 10 years ago. And they wanted to do a surgery on him, but he didn't want to get the surgery. And I think he just had soft tissue treatment and he had some maybe pain relief injections. And I think we got it in like 100, maybe 150, 160,000. So you could get a significant amount without any surgery. But of course, like, well, oh no, he's saying a fusion. No, if you need a fusion, it's worth more, right? Because you could say, look, I'm not going to do the fusion now, but I might do it in 5 years. But that's worth more because the fusion itself is like 150 to 200,000 sometimes the procedure. Plus, like there's adjacent segment disease. So if you have a fusion at one level, you may need it at the next level too, because it puts more pressure on the adjacent level. That's a known medical fact. So now you have two surgeries you're going to need in the future. Each surgery is like 100,000 or more, right? So that's like just the cost. The medical cost is like 200,000. So a fusion, I think you can do pretty well. You can get even over 500,000, maybe even closer to 1 million without surgery. But I would say it's probably better to get the surgery if you need it or are going to get it at some point. Better to get it at some. I'm not saying get it right away, right? You have time. Like if you're just filing a lawsuit, you might have like whatever 2 years, 3 years until the actual jury trial. But I would get it in that span before the trial because then you can claim it and you can get much, much more money as opposed to not doing it. You could still get money for the fact that you need surgery. But like if you get the surgery, I don't know, 5 years later, you can't come back, right? Once the case is over, it's over. So you only have one shot. So you might as well if you're going to do it, you might as well do it and get paid much, much more because having a surgery is worth much, much more than needing a surgery and not having it. But you could still get a large settlement. So either way. Okay, and Suzette is here. She says, "Hey, my lawyer. Hi, how are you?" That's one of our clients. Yeah, we settled her case. We were ready to go to trial, and then that was a fun one. Yeah, she's a really nice lady. And then yeah, surgery is back fusion. Okay, yeah. So sounds good. Sounds good. So let me know if you guys have any more questions. Drop it in the chat. Let me see. Make sure I have the right window open here. Live chat. Yeah, I think I have all the questions here. Yeah. So yeah, I'd be happy to answer any more questions. We've been on for a bit. We've been on for almost an hour. If not, then I'll run. But I'll do a few more videos. Yeah, I know as people had those requests for specific, like the scaffold lunate. So I'll do that. I'll do a few others. Yeah, absolutely. I'll take a look. Oh, here's one more question. Is it too late to switch to you? Case has been going on for 5 years. Do you think it would be a good move? I mean, I'm happy to chat with you. Just text me 347-566-9595. I couldn't really say. Sometimes it is and sometimes it isn't. It depends on who's handling it. It depends on a lot of different things, like whether the lawyer is a trial lawyer, whether they're willing to go to trial. So sometimes it does make sense, sometimes it doesn't. And I'll be honest with you. Like sometimes people call me and they say, "Look, I have this lawyer X, Y, and Z," and I say, "Look, that's a great lawyer. Stay with them. They're amazing." I don't really want to take cases from other lawyers. I'd rather get cases that are fresh cases because then I could get to know the client. I could build the case up the right way. Whenever you take a case from another lawyer, it's always difficult because you have to change something, right? And you have to, which you could do, especially if it's early. If it's like they just filed a lawsuit, or if a lawsuit has not even been filed, that's always a good time. If a lawsuit has been filed and there's a deposition, it could also be done. I mean, it could really be done at any point. Like actually with Suzette, I think she was already on the trial calendar and everything was done. Her deposition, the deposition of the defendant, everything was done. And the trial was actually like only like a month away. So that was actually kind of late in the game, but we were able to pull it out because I think we got about, what did we get, triple? Or I know more than about triple or close to triple, maybe double the prior lawyer's amount. So we did pretty well, but that's kind of like late in the game. I mean, usually. but it just sometimes it makes sense. So, because yeah, I think in her case, the prior lawyer was just kind of like pressuring her to take that number, which was like 3 times less than what we ended up getting. So, you know, okay, and then yeah, so it just depends, but I'm happy to chat. Just text me 347-566-9595. And then Oseni says, yeah, the scaffolding. I'm gonna say maybe I'll do it right now before I leave. And then I'll do a video about it for you. I don't know how many cases there are going to be about that, 'cause that's kind of a very specific thing. But maybe I'll be surprised. Maybe there will be a lot. Who knows? And Lost in Awareness says, can you negotiate a jury verdict if it's too high, so you won't have to go through the appellate courts? If it's too high, can you negotiate it? Yeah, I mean, you can. Let's say you go to court, right? And the jury gives you, I don't know, like 60 million, right? Like that verdict that just came down like last week from that guy, the guy who was teaching the course in California that I went to. He's a really good trial lawyer. So let's say, and then they say, you know what, we're going to appeal. This is against the weight of the evidence. The appeal is going to take you, 5 years. And then, look at the appellate history. They're going to say 60 million, you can't have that. You're going to have to take, maybe 10 million, or you're going to have to just do the whole trial over again. And then you're going to have to spend 10,000 per doctor, and you called like 5 doctors. That's another 50,000 again. And your client's going to have to wait 5 years. So why don't you just take, I don't know, 15 million right now? And then if the client's okay with that, and then the lawyer's okay with that, they could say, okay, done. And it's like a settlement. Yeah, you could do that. People do that all the time, in fact. That happens. Absolutely. Okay, so thank you for being here. I have to run, but I'm really grateful for the opportunity to speak with you. I always love helping serious injury victims and families. Like I said, don't hesitate to text me 347-566-9595. I just ask that you give me your name. Like you could just say John or whatever. You don't have to give me your last name. Everything is confidential. Everything is free. I don't tell any lawyers about anything. So everything is super confidential. It's the attorney-client privilege. And I just ask that you tell me the facts of what happened. Like I said before, like I fell, or I had a ceiling collapse, or I got rear-ended by a car, just so I have a picture, right? Imagine like I'm watching a movie and I see it happening. I want to have like one or two sentences. And then also your injury, like I had a back fusion, or I have a, whatever it is, fractured knee. And then also just include your city. Like I'm in Phoenix, Arizona. I'm in, Detroit, Michigan, whatever it is. So I could have an idea. And then I could schedule a call with you. We could chat and try to help out. Okay. Have a great night, everybody. Stay safe out there. All the best. And we will talk to you very soon. Please like and subscribe to our channel. And we are here for you. Okay. Bye-bye.